Good afternoon, everybody, and welcome to the ultimate session of the conference. I'm Mary Eaton. I'm a partner at Freshfields, where I co-head the Securities and Shareholder Litigation Practice Group.
And I'm Adam Badawi. I teach at Berkeley Law. I teach M&A, business associations, contracts, and I'm a co-host of the forum today. And it's our pleasure to welcome Justice Valihura for a fireside chat today. As many of you probably know, Justice Valihura is going to retire from the Delaware Supreme Court this coming July. Before that, she spent 25 years at Skadden doing corporate work. And she then joined the court and served there for 12 years and even spent, I think it was 7 days as the acting Chief Justice of the Delaware Supreme Court. So we're thrilled to have her to tell us about her time on the court.
So we're all very curious about the inner workings of the court. And I know there's many places that we cannot go with that topic, and I will toe the line, I promise. But it's a very busy court, as everyone knows. And it also hears cases from the family court, the Chancery Court, and the Supreme Court. How much of your docket comprises like corporate cases overall, would you say?
You might be surprised to hear that it's about, I would say, less than 30% of our docket. Probably 55% is criminal, and we have maybe 13% from family law, and there are other things, but and that doesn't necessarily translate into, the percentage of appeals doesn't necessarily translate into the time devoted, but that's about it. We are, unlike some courts, we have to take all of our appeals as of right from our trial court. So we are the final stop for family court, for superior court, and for the Court of Chancery. So we have no discretion as to which appeals we take, except for interlocutory appeals, and we take certified questions. And sometimes we can give advisory opinions to the governor or to members of to one of our houses of our General Assembly.
Right, so I was looking at the wonderful set of slides that you put together and recommend them to everybody in the room, which lists all the cases the significant corporate cases that were decided during your tenure. And one of the things I noticed in reviewing them when we were getting ready for our chat today is like some of the procedural differences. Not that I'm going to be wonking out on this kind of stuff, but they can really underlie some real substantive issues, right? So for example, if you look at that list of cases, there are some cases that were decided en banc, and there are some cases that were decided by a panel of 3.
Correct.
For example, some cases had oral argument and some cases do not have oral argument. And just for the people, particularly the people who aren't litigators, and don't practice before the court, like what's the difference? Are they worth the same thing if it's a decision of a panel of 3 versus the entire court? Is it binding on a subsequent panel? Those kinds of things.
Yes, they have the same precedential weight. So a decision by a panel of 3 is the same weight as a decision by a panel of 5, as is a decision by order. Sometimes we'll do just a summary affirmance. We may do a short form order. They all have the same weight.
Right. And what about oral arguments? If I'm denied oral argument, should I be worried?
Well, we hear maybe 40% of our cases by oral argument, and we select those cases for argument. So the cases that we select will be selected on the basis of their policy implications. There may be things that we need to have clarified. It doesn't necessarily mean you're in trouble if you don't get oral argument, but there are reasons why we ask for oral argument. Not every case gets argued.
Right. So the other thing I noticed is the per curiam decisions, which are decisions by the court.
Right.
And in particular, there was a recent decision in the Tesla derivative case that was decided just in December, where it was a per curiam decision of the court. So the question is, you know, what's that used for? What are the circumstances under which the court would issue a per curiam decision? When is it appropriate to do it? When it's not appropriate to do it?
We don't do it all that often, and there really aren't any written standards. It's purely a matter of our discretion. The one area where we do it with some degree of regularity is in the area of attorney discipline, where the court of that is in charge of overseeing all attorney discipline, and so those orders are usually per curiam. This was a case where, as you probably know from reading the opinion, the justices had differing views on the merits of the case, and so we just issued it per curiam.
On the narrow grounds on which the case was decided. But it was interesting, though, that the case actually says up front, we don't agree on these issues. A lot of per curiam decisions that you read, both from the Supreme Court of Delaware and other courts, they don't go into that stuff. They just say this is the decision of the court on this ground without signaling to consumers of the opinion that we're not all on the same page about the other issues.
Well, I'll give the same answer the Chief Justice gave at Tulane, as we really can't get into how the sausage is made behind the scenes. So that's about all I can say on that.
It is kind of unusual, though, is it not?
It is.
Yes, okay. Let's talk about the Delaware franchise.
Okay.
There's a panel earlier today. There's been a lot of discussion about the Dexit issue and the competitive pressure between Delaware and Texas and Nevada. How much of a role, if any, do concerns about pressure on the Delaware franchise play as you're thinking through decisions?
It really doesn't. I mean, I think embedded in that is the assumption that we are concerned or we're fearful or we're worried, and therefore we're going to tailor a decision a particular way. And I can tell you that that is not what happens. I think we decide the cases based on the law and based on how each independent justice feels about the case. And so there's no, gee, we got to go this way in this case for this reason, or politics, based on political dynamics, to the extent anybody can really read that. We don't do that. And so I can say, it doesn't play a role.
So the people who say, oh, the Delaware Supreme Court blinked at the Elon Musk compensation case, that's just not the case.
That's right.
Great.
So over your 12 years, there's been a lot of very big cases decided. They've touched on entire fairness, the ab initio requirements under MFW, what it means to do cleansing under Corwin. You've written a lot of big decisions. That includes MindBody, TripAdvisor, the Salzburg case, RBC. You've had some important dissents as well. I'm not sure if you're kind of at the point where you're reflecting yet, but are there ones that stick out to you as being kind of particularly important or consequential?
I think in that list, those were all obviously important. I would add to the list the Marchand case written by Chief Justice Strine. You've heard a lot about that today. There were a lot of other ones, like the Zuckerberg case, where we dealt with the demand futility concept and really came up with a new standard. The Koster case is another one that comes to mind, where we dealt with the Blasius standard and kind of assimilating that into the Unical standard. So each of those cases, I think, was important.
and at least 3 of those are in my corporate law casebook. So that's
okay, great.
Of note to me.
There should be some more from this past year.
I have to update my book this summer, and I have a lot of work to do. I'll kind of wish for the forthrightness of our keynote speaker. I'm not sure I'll get it, but did any of them, do you remember them as being kind of particularly challenging?
I think a lot of them are challenging. A lot of them involved issues of first impression. And so, we're looking at oftentimes coming up with a framework. Mind-body comes to mind. We were considering the scienter requirement and in a context of third-party buyers. And really there wasn't a framework. And so we developed one by looking at the restatement section. And so I think they're all challenging because not only are we resolving the case in front of us, we're thinking about what is the impact on the next case. And so it's that kind of thought process that we have to go through and with each and every case.
And are there any where you thought, well, maybe we could have done something differently there or have written it in a different way?
Hindsight is always 20/20. There are a lot of difficult cases that we've handled, but I personally can't think of one where I say to myself, gee, I think we got that wrong. There are times when the General Assembly tells the Supreme Court it gets it wrong, as it did in Match recently. But, I don't, as I sit here after 12 years, I can honestly say, maybe people think I got the decision wrong or got the opinion wrong, but I don't have any regrets.
And does the court have a sense for when a case is going to cause a stir or when it does, or is it sometimes surprising that you release an opinion and it becomes a tempest?
I think there are a lot of cases that have a lot of publicity. And so you always wonder how it's going to go. Are people going to accept it? Is it going to cause a problem? But a lot of cases that we do are in the limelight. The Tesla case was in the limelight. The Clearway case was in the limelight just recently. But that's not unusual, and it's not just in the corporate context. It's in other areas of law too. So we've got a lot of high-profile cases.
So shall we jump to the hot topics of the day?
Sure.
Director independence is a critical issue. It's relevant to the formation of special committees, for example. It's relevant to oversight liability under Caremark or Zuckerberg. And it's relevant to, in the M&A context, apart from special committees, if it's framed as a derivative claim, not an oversight claim, you still have those futility issues. So it sort of permeates the landscape, so to speak. Recently, roughly a year ago, I guess now, the legislature enacted Senate Bill 21, which amended Section 144, which in turn addressed director independence. And one of the things that it did was provide that for public companies, if a director is independent, considered independent under the relevant stock exchange rules, then they're presumptively independent and seems to have raised the bar on plaintiffs to show otherwise. There's a heightened burden that they would have to overcome in order to show that the director lacked independence. There's no legislative history to speak of here with regard to SB 21. I mean, there's lots of commentary on it, obviously, and et cetera, but it's not like, the promulgation of a federal statute where there's a whole record there for people to plumb as they see fit or not. What's your sense of why the legislature went this direction with the independence question?
I think what the legislature was really doing, we have a lot of cases in Delaware that say that if a director is regarded as independent under the New York Stock Exchange rules or the NASDAQ rules, for example, that doesn't necessarily answer the question of whether he or she is independent under Delaware law. And I think what the legislature was simply doing was taking that and making it into a presumption so that there is symmetry in that area. So I don't, I think what 144 was doing in a lot of areas was trying to take certain areas of law and draw brighter lines to eliminate some of the kind of fact-based litigation in certain areas, and I think that was just one of them.
So it's interesting, though, because the statute, at least on its face, this is in the context of Section 144, which deals with conflicted transactions, right? It's not a provision of the DGCL that relates to director independence generally, to go back to what we were talking about before. So it's really an open question as to whether this new statutory test is going to apply in those other contexts. And it certainly doesn't apply to private companies. That's clear, because they're not traded on an exchange, right? So I'm just wondering, like, how much, whether we're now in a situation where we have a presumption, a different presumption, a higher presumption for director independence in the M&A context versus what we had in Delaware common law for director independence questions outside the M&A context.
I don't see it that way at all. I think our common law has well ingrained into it the presumption that directors are presumed to be independent, and I don't think any of that changes because of 144. In fact, I think some of the synopsis says that the statute is not meant to alter a lot of the common law around these issues, so I don't see that as being disturbed in any way.
Okay. So many years before the statute was amended, in the Zynga case, there was an issue with respect to a couple of directors who the company determined weren't independent under the relevant stock exchange rules. And in your dissent, you held that that didn't mean you still had to do the analysis called for by Delaware case law, which is they're presumptively independent, and it'll be up to the plaintiff to allege sufficient facts to call that independence into question. And that the mere fact that the company had determined that they didn't meet the independence requirements of the stock exchange rules wasn't enough. Do you think that decision would be decided differently today now that we have this statute that says if you are independent under the exchange rules, there's this heightened presumption?
I don't see how, I don't really see the case being decided differently. That was an interesting case for those of you who aren't familiar with it. It was a 4-to-1 decision. I was the one. And the issue in the case was that one of the directors co-owned a small airplane with one of the controllers. And the plaintiff in that case had done a 220 books and records demand. However, the plaintiff did not ask for any documents regarding director independence. And so the only thing the plaintiff actually alleged about that transaction, that co-ownership of the plane, was that it was a business relationship, and it was a small plane, apparently. And so the majority found that a majority of the board, majority of the court found that a majority of the board was was not independent, and inferred from the complaint that there must be a very close personal relationship there that is of a bias-producing, disqualifying nature. And what my position is that if you're going to plead a lack of independence under Delaware law, you have to plead it with particularity. And the only thing this plaintiff could say about it was a business relationship. And the court had relied on the fact in part that in the plaintiff's brief, the plaintiff had said, well, the relationship was much deeper, it was a friendship. And my position was, well, you have to verify your pleadings, you have to plead particularized facts, and if you're only going to say it in your brief and you're not going to say it in your complaint, then you haven't done your job as a plaintiff. And so 2 of the directors were deemed to be not independent by the board, and there was no explanation as to why, nothing. And so in my view, the plaintiff had not done its job in pleading a lack of interest, and that's how the chancellor came out too. So I don't see that being decided any differently because of this change in the statute.
So you brought up Section 220 and the inspection demands, which of course is that's a very important thing in and of itself. There have been a huge number of complaints, 220 complaints that have been filed, as we were discussing before we met here for our discussion now. Part of the amendments last year, there were amendments to Section 220 as well. And one of the things that those amendments did was it defined books and records to include certain specified things, one of which is officer and director independence questionnaires. And then for documents beyond that, imposed a higher burden on the stockholder seeking an inspection to meet before they could get different records, meaning you're stuck with, from their perspective, not from mine obviously, you're stuck with the independence questionnaires and you don't get anything else unless you meet this higher burden. So what I'm wondering about is, it's not so clear to me that if the stockholder in Zynga had made a 220 demand, that they would necessarily get anything other than those questionnaires that wouldn't really bear on the kinds of things that they were trying to show in their complaint, right, if that makes sense.
Well, the statute actually defines a broader subset than just questionnaires. It's charter, it's bylaws, it's, I think, includes things like contracts on 122.18 and some different things. So it's not just questionnaires. So had the plaintiff made a demand under 220, under the new statute, they would be entitled to that quantum of information, and if they needed more, they would have to make the requisite showing under the statute.
Right. I guess the issue is, one of the purposes of the amendment was to, you can correct me if I'm wrong, obviously, was to sort of stem the tide of, to be clearer about what people were entitled to, and to stem the tide of litigation over stockholder inspection rights. It just seems to me like if you're outside of the defined category of books and records, and it does include other things, obviously, but it wouldn't have included, I don't think, the thing that the stockholder lacked in Zynga was, well, why exactly did the company determine that these couple of directors lacked independence? I don't think you'd see that in the books and records.
Well, they would get the director questionnaires, presumably.
Yes, yes.
Right.
I guess what I'm driving at is, is this really going to invite more 220 litigation now? But now the question being going beyond the enumerated categories in Section 220A, and is this something that we really want to have happen?
Well, I think we'll have to see how it plays out. Obviously, it was an effort to try to control the quantum of information and to define it to that sort of core set of documents. And I think you really have to go back to what is 220 and what is its purpose. It is one of the handful of summary proceedings that we have in Delaware, meaning these are actions defined by our statute that are meant to be very streamlined. They're meant to go very quickly. The court will not consider any kind of collateral issues in these cases. And over the years, they have just become bogged down with a lot of overbroad requests that are asking for emails and other types of documents that are expensive for companies to produce and just burdensome. And so these 220 cases, which are supposed to be really kind of fast-moving cases that are often precursors to asserting derivative claims, have really kind of taken on a life of their own. And I think the General Assembly was trying to address that. As to how it plays out and whether or not plaintiffs can get more, we'll have to see. We have other cases in Delaware, the Palantir case, you may recall, where our Delaware Supreme Court said, if the company has the habit of keeping its main core books and records, not in regular minutes, but if they're in emails or if they're in some other form, then they have to be turned over in that form. In other words, you can't avoid producing core documents because you don't keep them in the normal kind of formal corporate minute books and records. So there are ways that a company could be forced to turn over these other types of documents.
Can I ask one more question about, can't help myself, about Section 220? In the M&A context, we get books and records demands all the time in the context of a pending deal. And the list of requests in the letter go well beyond what's in the defined list of books and records. I don't think that most companies receiving such a demand would have any trouble handing over what used to be known as the core documents and now is defined as books and records in the amended statute. The question really is about going beyond that, right? At least the message that we on the defense bar got a couple of years ago was stop mucking around about this stuff, just give over the appropriate documents. Do you think that the court would decide those issues the same today, now that we have a statutory regime that says basically thou shalt give X, which you do, but if you want X plus Y stockholder, you have to meet this very high burden and only if the court orders it?
Absolutely. I think the court's going to enforce the statute. It's quite plain on its face.
Well, I enjoy that answer.
I'm sure she will be. We'll have to watch what our Court of Chancery does, but I would have every expectation that the court will enforce this statute.
So another hot topic has been kind of about the nature of the corporation itself and the degree you can possibly contract out of it, even potentially approaching some of the alternative entities and the freedom of contract. And a lot of that was kicked off by the Moelis case, where a stockholder agreement gave Ken Moelis kind of wide-ranging rights to pick directors and choose the composition of board committees. And the Chancery Court said that agreement was not all right and kind of was contrary to the nature of the corporation. That case made its way to the Supreme Court, and the court decided it on the basis of latches and did not get to the merits. So wondering, in so much as you can kind of talk about it, kind of what is, even though the merits are briefed, how does it happen that sometimes the merits are not the reason for the decision?
Well, We try to rule on the narrowest grounds possible. And, here we have a situation where the statute has been amended. And this case was not mooted by the statute. The statute carved out cases that were pending at the time. This one was pending. And the parties actually briefed both laches and ripeness as their, prominent arguments. And so our court had ready agreement on the laches issue, and as a matter of our own judicial economy, if we can resolve an issue narrowly, that is always our preference. So we did not reach the merits, probably to the great disappointment of the practitioners who wanted to know what we would think of the merits, but,
And some law professors as well.
and law, I'm sure.
Do you think there's a relationship between that and the predictability we've been talking about all day? So Eaton said, what I like about Delaware is I can go into my clients and tell them what the law is going to be. Vice Chancellor Will talked about the benefits of kind of simple and boring judging. Is there a relationship between that and kind of not letting disagreement sometimes reach the written page?
I think going forward, we have a statute that has clarified that issue. So I don't see that as, maybe there are a few legacy cases pending still, I'm not sure, but I don't see that as a risk here.
And perhaps related to that, the laches issue turned on the distinction between void and voidable,
Right.
Which has been something that I think lawyers have wrestled with for a long time. Do you have, for lawyers who are kind of wrestling with those issues, do you have any guidance on how you make sure it's the latter rather than the former?
It is a very, it's a difficult area. It is one that, we have addressed in a number of cases, the CompuSecure opinion, the XRI opinion. But I think Justice Traynor did a really amazing job in laying out the law on void and voidable. And so, that is a very thorough discussion, and it is the latest discussion of our court. I really don't have any more to add than what he did in his, I thought, excellent draft.
So the amendments to 122 still kind of carve out something that might be contrary to Delaware law. And you had your dissent in Menti Holdings, where you talked about stockholder rights that are so important that they might not be able to be contracted away. So where are we in terms of freedom of contract and the corporation? Is there still some part of it that has to remain and can't be touched?
That's going to have to wait for court development, but the Authentics opinion is a really interesting one, and I think that was a really interesting discussion. The issue there, if you haven't read the opinion, was in a private agreement whether or not you could waive appraisal rights and whether appraisal rights had been effectively waived there, and the majority held that you could, and I dissented in that case. And for a couple of reasons. First of all, I didn't think the actual waiver was clear enough. There was a termination provision in the contract, and it wasn't clear to me that the so-called waiver or refrain provision survived that. But beyond that, we got into a discussion about, an interesting discussion about, are there provisions of the DGCL that are so important that they are important to the corporate brand and corporate form that they cannot be waived. And interestingly, even the majority agreed that there were some. If you read the majority opinion, which Justice Montgomery Reeves wrote, and did a really nice job, I thought, what she says in response to my dissent was that there were some that dealt with stockholders' ability to kind of root out mismanagement and stockholder, dealing with a stockholder balance of power. And I think generally what the majority was probably talking about, and what some commentators have been talking about, is 220. I would put 211C perhaps in that category, having periodic election of directors. That's another summary proceeding. So if a company hasn't had an annual meeting for 13 months, a stockholder can go into court of chancery and compel one, get the court to compel one. The other ones that I think may fall into that category are that commentators have written about: the right of a stockholder to vote on a merger, the right of a stockholder to vote on a charter amendment, for example. So those handful of stockholder rights are considered, I think, fairly important in Delaware corporate law. Now, in the alternative entity context, you can waive books and records rights. But there's that interesting discussion. One of the things the majority pointed to as to why you could waive appraisal rights was that 262 for a long time, for a number of years, had a de minimis requirement in it. In other words, the statute was amended so that you had to have either $1 million in value or 1% of the shares. And an appraisal petition could be dismissed if you didn't meet that de minimis requirement. And so that was one of the things the majority said, well, if you can do that, why can't you waive the whole thing? So you could get into a bunch of interesting discussions now, like, can you have a de minimis requirement in 220? I'm not going to answer that question, but you can come up with arguments, couldn't you, on both sides? You can say, well, in the appraisal context, we did a de minimis requirement, and the General Assembly just modified 220, and they didn't do it there. What does that mean? And is 220 somehow different than appraisal in terms of the balance of power between maintaining that balance of power and stockholder rights? Obviously, stockholders have the ability to elect directors of corporations, and so it would be very odd to take that right away. That would significantly alter the balance of power, and I think alter fundamentally what makes a corporation a corporation.
We are kind of out of time, but
All right.
with your permission, if we could take a minute just to touch super briefly on aiding and abetting.
Sure.
Which you mentioned in your remarks earlier.
Right.
There have been like several aiding and abetting cases recently, including the mind-body case that you talked about in Columbia Pipeline. I think the consensus is that those two cases together really narrowed the circumstances under which one could successfully sue somebody for aiding and abetting liability. And it's something I assume that you agree with, that was the intent of the decisions, was to make it clearer and more self-defined. Mm-hmm. Is that fair?
That's fair.
Yeah. Now, both of those decisions, Mind-Body and Columbia Pipeline, dealt with aiding and abetting claims against buyers, right? Which
Correct.
At least one could hypothesize, like a true third party, mm-hmm. right? Engaged in arm's length negotiations over an acquisition. It did not deal with aiding and abetting claims against advisors, which was the subject of a prior opinion of yours in RBC. There are some people who say you can't reconcile these new cases with RBC, and we can leave that debate to the people who want to engage in it. But really, when you're trying to wrap your mind around how do these cases apply to aiding and abetting claims against advisors, financial advisors, or what have you, are we talking about a regime? These are the issues, these are the questions that apply equally to advisors. This is not just a test for buyers? Or how should we be thinking about it?
Well, to rewind and respond to a couple things you said, I was the author of both RBC and Mind Body, and RBC, as you point out, involved advisors, and that was a case involving some really kind of egregious facts, and the appellants in that case made it very clear to our court that they were not challenging any of the facts. So the factual record came to us without challenge. And so the trial court had found in RBC that the advisor had essentially duped the board into breaching its fiduciary duties. So there was actual knowledge there, and there was no question about that, about the scienter requirement having been satisfied. And so I think what you may have been alluding to was we had quoted in RBC the scienter requirement from 3 or 4 other Delaware Supreme Court cases, which talked about actual or constructive knowledge. And so in Mind Body, we were dealing with a different scenario involving third-party buyers. And so we were dealing with, as an issue of first impression, what was the level of scienter that was required. And we didn't really have a framework to analyze it. And so we looked to the Restatement of Torts, Section 876, and developed a test for it using the Restatement of Torts, where we said you have to have actual knowledge of the primary actor's breach of fiduciary duty, and the aider and abettor has to have actual knowledge of the wrongfulness of his conduct. And so we made it very clear that that was the level of knowledge for aiding and abetting liability. Do I think there's a different standard for advisors? You know, I'm speaking only for myself at this conference, and I'm a bit of a lame duck at this point, but I don't think what we were intending to do was come up with one test for third-party buyers and another test for advisors. We said in both cases that this is one of the most difficult standards of law, of liability to, if you're a plaintiff trying to assert. And I think it's true in both contexts. So RBC was, as we said multiple times in that opinion, it was a narrow opinion, and we were not adopting, I don't know if anyone remembers famous footnote 191, but we said we are not adopting the trial court's gatekeeper characterization of financial advisors, where the trial court had alluded to financial advisors as sort of being a gatekeeper, and we said no. This is their relationship is not that, and this is a narrow form of liability. So that's my take on it.
Thank you for indulging me. I know we're past the time.
Please join me in thanking Justice Valihura for her insights and forthrightness.